everyone, I'd like to welcome you to this session, which is Intersex in the Law, and this is presented in partnership with UCL Grand Challenge and UCL India Voices. I'm now going to hand over to our two people in conversation, Geeta Lutta and Geoffrey Yeung.
Why is this so silent? Hello everyone. Hi. It's late. It's a bit late into the day, I know. And this is a panel about law, which probably sounds a bit dry to a lot of people. Not for me, because we do law. I study law, and Geeta does law. But thank you everyone for being here. I think we are both very happy to see you all interested in this topic, and we're very happy to be able to talk a little bit about the topic. And I'll just do a little bit of introduction of us first. So myself, my name is Geoffrey Yeung, he, him, gender pronouns, and I'm from Hong Kong, originally from Hong Kong. I'm now doing a postgraduate degree in law in Oxford. I was an LGBTQ activist from Hong Kong, but also I worked also closely with intersex and trans activists in Hong Kong as well. So that's where I come from. And Geeta is a senior advocate at the Supreme Court of India. And do you want to do a little bit?
You want me to introduce? Sure. so I've been doing this for many years. For the last 37 years I'm practicing in the courts. I did two postgrad degrees in Cambridge, an MPhil and an LLM, and I'm practicing law, a lot of gender issues, women issues, and I've done one or two interesting cases dealing with intersex people. I'll talk about it when we talk. I think if I go on, lawyers speak a lot, so just you can tell me. Thank you, that's enough.
So she has told me that I will cut her off when I feel like she's talked too much. So if I did, it's not because I'm rude. She told me to do that. So also I need to tell everyone that if you want to tweet about the conversation, you should use the hashtag QA2017. You might have heard this like for a million times already. And add QA 2017 if you want to tweet about it. But if you want to take any video or photos, I think you're supposed to have to ask the organizers for permission. If not, then no, that's fine. Oh, not for this session. Oh, okay. You're free to like take photo with us. Yay. So also, well, I don't need to go for this. See, I'm just a rigid lawyer. So I guess the flow of this. Sorry. I guess the flow of this session will be more like this is sort of 1 hour long session, but if we just keep talking, it will be very boring. So we will talk for about 30 or 40 minutes. We'll sort of hopefully in a format of a dialogue to bring in a perspective from both India and Hong Kong on intersex issues, and the rest of the time will be open up to the floor. So prepare for questions, otherwise it will be very awkward. Okay, so let's start.
So would you like to start? I mean, I think you can give an introduction about transgenders and intersex, or I can do it, one of the two. So I thought you could do that, and then I would talk about some of the cases in India, and one particularly the case that I've done, a few years ago.
Yeah.
So if you could start on that, and then I would elaborate on it.
Okay.
Is that okay?
Sure. Just in case, I think just some basic definitions, I guess. The LGBTQIA plus acronym, so two of those which are quite often confused is actually T and I, transgender intersex, to the extent that activists from Hong Kong, intersex activists in Hong Kong, did make an effort to distinguish, to educate. Like at one point they were actually saying that don't call us LGBTI, call us LGBT and I, because people keep confusing between transgender and intersex. Of course, there are a lot of reasons why eventually the activists also came to accept the acronym LGBTI, because ultimately it's they are tackling quite similar issues and for solidarity reasons. But so the idea of being transgender is to identify with whatever gender, and that's regardless of whatever anatomy, whatever bodily anatomy you have. But being intersex is more about the bodily anatomy, and they may identify with whatever gender, but being intersex is more about having an anatomy that is not traditionally male, not traditionally classified as female, but of course there are also intersex persons who identify as non-binary, there are intersex persons who identify as male or female, and that has not, like, gender identity of intersex persons has nothing to do with their bodily anatomy, and that is just some, I guess, basic definitions about intersex people. And I guess the situation then is also that because they are also because of the gender binary in society, then one of, like, there are a few many issues that intersex people have raised, and two of the major ones would be discrimination and pathologization, and that's because of the way in which gender binary is often enforced on people. So that for example, intersex children would be forced to receive corrective surgeries, genital surgeries, when they were very young, and which means that, and this is, like, from one of my very good friends, who's a very brave intersex activist in Hong Kong, and her name is Small Look, and I encourage everyone to look her up. This is, like, very important because I think it's very important for you to actually look at the voices of intersex people and not rely on us. But it's and her organization is called Beyond the Boundary, and her work has been amazing. But she has also, like, talked a lot about the impact of corrective surgeries done at so young without their own consent, which can turn out to be wrong all the time, because doctors simply they have no idea about the baby's or the children's gender identity, and they just try to conform them to one or the other, which means that they can be wrong, or in any case they are without the consent of the babies. And the other issue is, of course, discrimination and maybe even visibility, because intersex people they can be very invisible, especially in today's society. I think intersex people have even much less visibility than trans or even other letters in the acronym. And so I guess that's true in Hong Kong, and maybe that's also true in India.
So there was one aspect that I was thinking when we've been discussing, and this is, should the parents have a right to get some correction, which they call correction, when they discover the baby has features which are of both genders, or should they leave it for the child to determine when the child grows up? Now, in intersex, there are some 8 issues which come up, which is, if there's in a XY chromosome or XX chromosome, there would be, say, complete insensitivity to androgen. So if that happens, and that's the case that I will discuss because that's the one which I had done, if there's so you are XY, so you should have been a boy, but the fact is, if there's complete insensitivity to androgen, then you would grow up as a female, you'll have a uterus, you'll have breasts, you'll have everything about a woman, and so the parents would not realize, because nobody goes and gets the chromosome checked when you are a baby. So somewhere along the way, if the sensitivity becomes partially sensitive, like an 80 or 90% or a 60%, then some features will come. Now there will be cases where the parents will not know. So there are 4 such kind, which are called androgen insensitivity, 2 syndromes, the Turner syndrome, another syndrome, vaginal agenesis, where at birth there is nothing. And then there are those in which there is birth, there would be a gonad, there will be a partial gonad, there won't be. And that's because they would produce, if they have a male hormone, then the girls will have some physical features of masculinity, or the other way. Now question would be, should the operation be done by the parents, because at that time the parents are the deciding factor. Now, one of the issues that's coming up is parents should not do anything and it should be left to the child when they become adult to decide. Now, that's a very difficult issue, because your parents decide about many aspects of your life. Which school you'll go to, where you'll go, what you'll do. So question is, can you then say, no, parents, you can't decide this area, but you can decide other areas? Or should it be that in cases where the person's 18, then they should have a right to decide, but if parents have done something, then you can't find fault with them. The other aspect is education of parents. At that time, the parents would not be aware. They'd go to a doctor and the doctor would say, okay, this is the slide, they would do chromosomal tests and they'll find out if this person is got 46 chromosomes XY or XX, and even with that, is he resistant to any hormone, and therefore make a determination. So this is a very difficult area. Frankly, it's a very difficult area, and I think it takes us years, even if we may keep debating, it'll take us years to decide on this. I was just trying to tell Geoffrey this aspect, that this is where I feel we need to think about. Now, coming back, Geoffrey will take on and then I'll talk about the cases.
I think I just also need to lay out, I think it's very important to lay out that according to many of the declarations from the intersex community, their stance is actually quite clear on this. Corrective genital surgery should not be performed on intersex children until they have the ability to consent to it. Of course, unless they are at critical immediate health risk, and that's of course a different procedure. But the intersex community is actually quite clear. Although there are the issues, especially the legal issues, might be difficult to delineate, but the stance, at least everyone can Google, because you're all on laptops. Google the Malta Declaration, which is from the Fourth International Intersex Forum, or many of the regional declarations from Australia, Hong Kong, and Europe. They have their clear stances on the issue. But having talked about intersex people, I think you were actually leading to one of the cases that you were talking about, the case that you worked in. Do you want to talk more about?
All right.
Yeah. Sure.
So in 2008, this is about intersex person, and of course, these parents in Lucknow in India had 3 children, all intersexed. So this one child and all of them were brought up as girls because they have complete androgen insensitivity. So even though they are XY chromosomes, everything about them was female. Now I'm talking about the eldest child who felt, and in India you're ostracized and it's very difficult, and they live in, although they live in Lucknow, in the capital city of Uttar Pradesh, it's a very conservative, low middle class family. And this child at 15, she'd been brought up in a girls' school. She had all the physical attributes of being a woman, suddenly saw some secondary features of male, just some gonad appearing, and she went to the doctor, and the doctor then did all the tests and said, she had XY, but because there was 100% insensitivity to androgen, everything about her was female. But she had this, and the doctor then operated on her. She thought like a woman, she psychologically was a woman, everything about, she'd studied, her whole makeup was that of a woman, physical appearance, psychological, everything. And the doctor who treated her was an endocrine specialist, surgeon, and in Chandigarh, in PGI, Sanjay Gandhi, which is one of the very prominent hospitals there. And all that she had after that minor surgery was that all that she had to do was that she had to take one oral contraceptive pill, which women have to take every day of her lives. So 5 years down the line, she applies for a paramilitary force to take up a job. And so she clears the written exam, she clears the physical exam, and she's 55 kilos, a little, not a very strong, I mean not a very large, short, small, petite girl. And she clears everything, but when she goes for the medical, her doctor at the end of the form had certified that she had undergone a gonadectomy as well as a vaginoplasty, and said she is perfectly capable of taking any job of whatever nature as a woman. And so she applies for a woman constable, woman sub-inspector position in a border security force. Now, even in the West, many judgments that I have read, in the military they are very hesitant because they feel maybe psychologically the person will not be strong, this, that, the other. So we file this, so she fails the medical test and they don't tell her the reasons. And finally we filed this petition that she has not been given a job. We knew the reason. I mean, we knew it was because she had got these operations done, but they didn't tell us the reason. So we filed the case and the court said, this is unfair. You have to tell the person the reason why she has not been given her job if she's cleared the written as well as the other exam. So they give us the reason. They have to give it in 1 month. They give us the reason saying congenital anomalies. Now in the military thing, among the grounds of denial in on medical ground is congenital abnormality and some other medical grounds of denial of appointment. So we go back to court, file another petition. We say this is, unjustified. And the question is, now in courts of law, can you pick on an administrative decision made by a medical board of 3 people? Ultimately, the courts are not going to go over the decision of an expert. So we were working on very, very difficult, slippery ground. So I tried to say this can't be a congenital anomaly, various arguments which we tried to give. The court said, all right, call the records. So the records were called. And we also tried to go behind the medical board and said, who were the experts who were doing it. So it was 3 MBBS doctors. So one of the grounds that I said is no expert in endocrinology. There is no gender expert, there is no endocrinologist, there is nobody in this department. So how were these people saying it's a congenital anomaly? So we file an appeal to the Review Medical Board. Review Medical Board and the Additional Director General, who's a doctor, also look at it and said, no. This person is on cortisone and something else, they said. I've got the judgment before me, but it says cortisone and in future will have behavioral disturbances or some such thing. So where do you get that, sir? So we questioned that and we said, this is not correct. And how can you be saying he's on cortisone? Where's the cortisone? So then the Dr. Bhargav, who had done the operation, said, I have told you that all this person takes is Oral, which is a oral contraceptive which many women take and which many women have this problem that they may not have enough female hormones, so just to see that the balance is there and to make sure that the bones remain strong in women, we give this oral contraceptive. And the only thing is she won't be able to have children, but that in the normal way. So don't use this to deny her job. So we had a very proactive doctor. No, normally a lot of the doctors will say, look, we don't really want to put our nose into it. Why do we get into a court case? Why do we get into? But luckily we had a very proactive. In fact, it's the doctor who had referred this lady to me to help her. So, of course, and she was poor. She would come with some. It was pro bono. She would come with some 20, 30, 40 pounds from that place and say, I don't really have a place to stay and I have no money to give you, but can I offer you half and I'll use half to go back? I said, no, you keep this. But of course, when she won the case and when she got employment, she came back to offer me something. And she said, so that you will help other people also similarly situated. So I said, no, don't worry, I'll help them anyway. But so the court looked at all this and said, you can't discriminate. The Indian constitution is really strong and robust. It's how we implement it and how we look at it. So it says, Article 4, am I going too long?
No, go on.
All right. So the Indian Constitution is very strong. It says equality before the law. You can't discriminate against anyone on the ground of sex. You have to do affirmative action. And on the affirmative action, I'll tell you about a recent 2014 judgment of the Supreme Court of India. So I'll just tell you about that in a while. And so it looked at all this and said, there has to be a rationale. You have to have qualified doctors who look at it. You have to have experts who look at it. And you can't just be using the word cortisone. You can't be saying congenital abnormalities. Is this going to affect her career? Is this a problem which will make her less efficient? Because we realize we are dealing with the paramilitary force and we don't want unfitness. But you can't say she's unfit just because she has to take this hormone. And anybody could be taking some medicine. So this is unfair. And it said, the judgment of course is a little cautious and says, it's not that we are saying across the board that fitness is not relevant for the military. Of course it's relevant. But this person is not unfit. So it goes into that, and then the long and short of it is that we succeeded in the case, discussed various US judgments, 1 or 2 EU judgments, 1 Indian judgments on which equated the same thing as where women were, because women who were air hostesses were denied to continue to serve in service if they were married or if they were a certain age. And the court said that if there's no discrimination on the ground of sex, then you can't do this to women air hostesses. And then it discusses all these cases, including the fact that Article 14, 15, 16 says affirmative action, and that even affirmative action has to be taken to ensure that there is no discrimination on the ground of race, color, sex, whatever, caste, and then holds enough in favor of the person. But by then 3 years had passed, so they said go through a retest of physical fitness, and if you are fit, you'll get the job. She got the job. So this is one of the cases. I'll discuss other matters which I haven't done but which are also interesting, but I'll let Geoffrey have a word in.
No, it was like when I was reading the case, because Gita very kindly shared with me the judgment, there were 2 things that really jumped out to me. The first thing is there are two things. One is not very legal, and the other is very legal. The not very legal one is how much the authorities, the government employer in this case, deferred to a medical authority, which has no specialist on the matter, but how much weight they gave to these doctors, even though they had not really any specialist knowledge on the matter. And that's actually quite common. That really highlights one of the things is how much power doctors hold sway, not only among the general public, but also in courts of law. And that's one thing that is very, very striking, is that actually that happened also in transgender cases when they were in early cases. In 1970s or 1980s, courts very often invite a lot of expert evidence on, and these experts are always doctors who may or may not know what transgender is, and they will give a lot of weight to what these doctors say about the identity of trans people, even though obviously the identity is, the doctors can't really assess the identity of a person. They can assess their health conditions, they can assess their bodily conditions, but they can't really assess the identity of a person. But this is still happening in intersex. Like, doctors hold so much sway on this matter. And the second thing that really, which means there is a point there, actually. The point is that and medical awareness within the medical profession is extremely important. The first thing is because I don't know why people would listen to doctors simply because they claim that they say they're doctors, even though they don't really know intersex issues. The second thing is more like, I've personally, when I was in Hong Kong, doctors are very, very highly regarded. I guess any kind of professional jobs are very highly regarded in these kind of cultures, but
doctors more so, I think.
Doctors, I don't know. It's probably a function of how much they earn. But doctors are very highly regarded, and so are medical students. But it's just like not long ago. I've discussed sex and gender issues with local medical students, and they're still arguing. They are now willing to accept that gender is a spectrum, but they're still arguing to me that gender is a spectrum, but sex is not. Its conditions between sex are far and few in between. They are not a spectrum. And I was like, dude, you're the doctor. I mean, I don't know how I can convince you, but just listen to the verses for others. But the other thing that really jumped up to me is how extreme this case actually is. In the judgment, the reason I was going the phone is not because I'm playing a game, but it's because I was looking at a judgment, and the judgment said that the evidence, the decision here to not employ the intersex plaintiff was based on, now I lost it again, was based on, like, it used very extreme language. It was based on extremely sparse evidential record. It was extremely, like, there were completely no evidence to the fact that, to the point that the plaintiff was not suitable for the job, which means that it's pure prejudice that is at work. It's purely not just misinformation, but pure prejudice and speculative prejudice that is at work. And the lucky thing about this plaintiff is that she applied for a job at the government, which meant that the Constitution would be at work, which meant that they can use public law arguments to argue that the government cannot discriminate. But that wouldn't occur in the private sector. The private sector, at least not in Hong Kong, there are different situations in many countries, but like if you're in Hong Kong, and I think also in India, if you're in the private sector, which employs the vast majority of people, if you don't have a discrimination law, they are free to discriminate. And that would be like that, and that is the point where I want to bring in. Do you think this case really highlights in India the need for something that we have to do with the law to make sure these things don't happen, because this is just pure prejudice at work?
Of course, it's just pure prejudice at work, where all I can say is that if you look at the history in India, the fact is that basically we're a very tolerant nation. I mean, everybody, one of the things which will stand by is that anybody can come walk over you and you are very tolerant. But when it comes to for example, transgenders and intersex people, the fact is that in India they were considered, historically, they were considered almost holy, in the sense that they could give you blessings. So their blessings meant a lot. And if you look at the Hindu scriptures, in the Mahabharata, the person who won the war for the side that was so-called good over evil was because he defeated, it was a person who was intersexed who defeated a god, virtually a living god, who was Bhim. And how he defeated Bhim was he defeats him or kills him, and that's why they won. So there was a blessing that had been given to them that, you know, they could in fact bless people. Now in practice, when the British came, then the Criminal Tribes Act came in 1871. So anyone belonging to them somehow was treated as criminal per se, and therefore 2 years imprisonment per se for just existing. And that was abolished only in 1949 or something, not that long ago. So that that marginalization has happened in a very big way. So families would not want to have people who are intersexed within the family. So the question is, would you disown them? Would you send them on the streets? Would you kill them? All sorts of practices have been prevalent. And because they are marginalized, therefore the problem in India is really more serious than appears. So this case would be an off case. I mean, it's a one-off case. The law is changing. I mean, it's changing not because the government or the executive and the legislature has done much about it, but because the courts are taking these baby steps, which are very good. So the law is a little removed from the reality. So we may be a little progressive in the law, particularly in the 2014 we had a judgment where the court discusses this and therefore brings in a third gender for the first time in India. So it says not he, she, will be also a third gender. And it went as far as to say that it is the person's choice to decide if they belong. If they come to you, they say I'm third gender, then that's what you have to reflect. But there are subsequent judgments where State Bank, which is like a public sector bank, and again in the constabulary in Tamil Nadu, again this issue came up, and the question was, why are you not still having a provision for third gender? Because there are online applications, but it was male, female and nothing more. So then they went to court, and based on this Supreme Court judgment of 2014, the court said, sorry, you have to consider them even though you don't have a third gender, because Supreme Court judgment says you've had to have a third gender. So if you don't include it, State Bank said, sorry, we are not government, only government is bound. Now this is one of the restrictions. Only government is bound by the fundamental rights, which would be there in all common law countries across board. So it's only government that is bound by this. And they have also suggested affirmative action. So I'll discuss later another judgment where affirmative action was interpreted to make the essential criteria, to mellow it down, to provide for admission, because it said we have to encourage. But in India there is still a big wide gap between reality and law. So the courts are being progressive, but the practice is still not at all progressive.
I'll give a little bit background about the judgment that you talk about. It's called NALSA, and what it was decided in that case was that it was mainly decided for transgender people, but it decided the results were actually very useful for anyone not in a for anyone who's crossing the gender binary, in essence. Like the transgender, like it was like a very important judgment which was reported around the world. But I wonder, like, they also like mentioned something like huge. Like in the judgment, like they not only cited the history of transgender people in India, and the disruption that British colonialism has brought, and they explicitly used the word paradigm change. They want to achieve a paradigm change in the law to that we are now away from the gender binary that this British colonialism disruption has brought. But there are two questions here. Like, firstly is how much does that judgment benefit intersex people? And secondly is if when you see that, even though with that judgment, you will just talk about how there are still so many local authorities that are still not following it. Has it really achieved the paradigm change it has achieved? Like, what's blocking it?
So it hasn't achieved the change that you were looking for. One of the things the judgment says is you just have to say, sorry, go to your government authority, tell them I want third gender, go to the passport authority, go to your election card, go to everywhere and say I'm third gender, please have that criteria. And it is your perception which should count. But there's a problem. And that is that it also says there should be affirmative action for those who are either third gender, transexed, transgenders, intersex, etc. What it means is that you will have in jobs, in education, you will have reservation. Now, I don't know whether anybody is aware of this, but India is a country where there is reservation, more reservation, and still more reservation. So that there is a very small window for those who go into merit, and the rest is covered by reservations. Reservations for what we have, the underprivileged classes, scheduled class, scheduled tribes, which were considered in Gandhi's time untouchable, and then other backward classes. So there are lots of other backward classes. Now in law, by judgment of the Supreme Court in 64, it was said we can have 49% reservation. But because the vote bank everybody wants to cater to, so in invidious ways they try and even increase this 49%. Now the question is that if you're going to make 2% reservation for third gender, then will it be within this or outside? And we've already seen that there's an abuse for affirmative action, because everybody wants a government job, everybody wants admission into a class 1 institute. Now therefore there's likely to be people who will misuse it and say I'm the third gender, even though they may not belong to the third gender. So in a new bill, I'm just telling you one of the reasons why its implementation is not being done. So a private member, and there are private member bills and government bills. So government bills have a more smooth sailing because obviously the government, which is the party in majority, supports them. And then there are private member bills which may be one person, and he will just hope that everybody in parliament will become alive to this real problem and will support the bill. So one private member bought a bill based on this judgment, which we were both talking about, and tried to bring it into a transgender bill of 2016, 15 or 16 I think. But the government said, no, this bill's got very flawed and we will bring the real bill. So they told that person, you withdraw it and we are going to give a bill. But their bill, obviously, because government will think in its straitjacket manner, says, no, we can't allow people to say I am a third gender and accept it. We will test him medically through a board which will have one psychiatrist / psychologist, one endocrinologist, one government officer, one so on, so we'll have a board. So basically you are again mired into red tape. And that becomes necessary. I think what they should do is a person can declare, but if they want a job or if they want reservation, then they should have to go to the magistrate. You can't mire everything such that it becomes zero. I mean, the entire purpose of the judgment then comes to naught, because what the government's bill is saying is, no, nobody can just go and get registered as a third gender. You need a medical board, you need a full, not a medical board, but a full board of all these persons, and then they will give a certification, and then you can get third. So the entire purpose is lost of that judgment. There are many other aspects of that judgment which was slightly, I think it was a great step. So it's made people start thinking. That's an important thing. It's made us come alive to this issue. So the judgment has taken giant steps, but in reality, because of this bill which the government is trying to introduce, it's 5 steps forward and 6 back. So we are still at somewhere only a little further than the starting point. So that's what it is. And there are many other aspects of the new bill which are being heavily criticized. This is just one aspect of the bill. But that's why the judgment has not taken off the way it should.
I think just I'll just bring in one more perspective and I'll open the floor because I notice the time. But
Yes.
I think there's a huge problem about implementation of the judgment. But I guess one thing that judgments like these do is that they open up a discourse. They open up discourse for they have opened up a discourse for transgender people, but I don't. At least in Hong Kong, the same discourse for public discourse for transgender people has also been opened up by a judgment from the Court of Final Appeal, which was in 2013. And in that case, it was actually a very limited judgment. They recognized the right of a trans person who has undergone a so-called full set of sex reassignment surgeries to be able to marry the opposite sex. So basically, it's the least they can do, but the impact of that is that it really opened up a discourse about transgender people. And not only has it opened up a discourse about transgender people, to some extent, maybe partly because of so much confusion about transgender intersex people, it also opened up a space for intersex people to raise that we are different from transgender people. It became an anchor point in which people who are non-gender conforming or doesn't conform to the gender binary, no matter trans or intersex, to be able to latch onto this and make a public demand. And I think this is one way in which, even though the law would make a baby step, even though in the implementation it will go back a few more steps, but it will help change the public discourse. And this is one way in which the law is very oppressive, but also can be very empowering. Now I'll open up the floor for questions because we don't have that much time. Then 2. Yeah, I'll take a few questions and then answer.
And
1, 2, 3 then. Yeah.
What, sorry?
1, 2, and 3.
I wanted to get a bit more context on affirmative action and the reservations you were talking about. Could you be a bit more specific about who's abusing these reservations? Not just in terms of the third gender ruling, but also general kind of affirmative action.
so the third gender issue hasn't taken off yet, as I said. You know, one thing for the courts to say affirmative action, but it has to be made a reality by giving the reservation across board and this government, because it is reservation can only be in government bodies, in government institutions, government schools and government colleges and government employment. This is one aspect, because you can take these measures are available only against government. Now as far as the third gender is concerned, they will have the right once this legislation comes in. The only salutary judgment in this is a judgment of the Madras High Court, where again a person applied in for the police as a sub-inspector, and this person applied as a woman. First this person applied and saw no category for third gender, went to court, and the court gave an order. This person is allowed to apply as third gender. So the application form was taken. Then what happened was that this person then had an issue with physical fitness, that there was a shortage of 1.11 seconds than what was permitted. So you have to finish a race in 27 or 37 or some such seconds. It was short by 1.11 seconds. So ineligible. The matter, and before that the matter went to court another 2 times. On every step it went to court. But Atri was a very determined person, and finally when the court said that if Supreme Court has said that there should be reservation, then surely we can ameliorate the condition of 1.11 seconds, because we have to encourage transgenders. And therefore, the person got the job, despite the fact that they did not fulfill exactly the cutoff of the eligibility criteria. So this is one aspect. The second aspect of your question, how is it being abused in India? So it's being abused in India by, obviously, how you abuse. People will try and declare themselves as OBCs, other backward classes, or scheduled caste, scheduled tribe, get false certificates and try and get, sorry? When they are not actually part of those groups. So that is why the government has brought this criteria, but it's defeating the purpose of the judgment. So they have to, I think it's only for the reservation part that they should require a mandatory certificate. But at least for being declared third gender, then if they bring it, and then the government's bill has another anomaly. They say in employment you will get reservation, but not in educational institution. Now if I don't get education, then I can't get employment. So there are many anomalies. These are just 2 anomalies. So this aspect is there, but there are other aspects. You see, there is, even among scheduled caste, scheduled tribe, there becomes a creamy layer. Those who traditionally have been doing well, they take away all the jobs and employments for reservations. Those who are really needy miss out on them. Sorry.
Okay, I need to make, it's okay, I need to make an announcement. For those who want to attend the IOS Living Disobediently, which is another panel in the conference, please go to the reception now, basically. But if anyone who wants to stay for a few more questions, welcome. I'll take 3 questions at a time, and we'll answer it together. That will make it fast. Oh, yeah.
Thank you. It's really just a point of information. Sorry if I missed it, but could you say the name of the case, the first case that you were talking about, the intersex case?
The one which I did?
Yeah, and is there
It's called Faizan Siddiqui.
Okay.
It's a 2011 judgment. It took us 3 years to get the final order, but it's called Faizan Siddiqui. And the citation... yeah.
Is there any easy way to find it online?
The easiest way is if you give me your email ID, I'll forward it.
Got it. Thank you.
I think
I'll do it after the session if you don't mind.
You may have a lot of emails to send then. I'll take two more questions at a time. Yeah. Oh, I'll take them all at a time. That will quicken stuff. Yeah, I'll take all the questions at a time and we'll answer.
Yeah.
Yeah.
Thanks for this. I've got one question though. I was wondering, you were talking about affirmative action that with section 377 of the Indian Code.
So
I'll take the.
you want to say, I'm sorry,
I'll
yes,
take
sure,
the two
sure,
more questions
sure,
and we'll answer
sure.
them together. That would
Sure,
be
sure,
quicker.
sure.
And someone else?
There were three.
There were three, yeah.
Love the mic if you're on that side, if you're close enough.
Oh, we
I don't need the mic.
actually need the mic for the recording.
Thank you. This was really interesting. My question is again about the reservation, the concern about the misuse of the reservation and the solution that you're pointing out to, that maybe instead of saying that you have to have a board for every sort of every step, have the board for kind of like the employment step. But even then, what would the board look like and what's the criteria? Because if it involves, for instance, surgery, that is not always something that everyone wants or needs, and sometimes it is a psychological gender identity. So would that exclude those people who identify as gender fluid or even transsexual but do not want a surgery? So would that how would the board deal with that?
Okay. Two more? I saw two more hands. In whatever order. Yellow shirt and checkered shirt.
It is really interesting, and I think my question is more relevant to how activism is run, because especially Geoffrey mentioned that in the circumstances where anti-discrimination law is absent, I wonder how much can activists rely on international human rights treaties, namely how much the governments and courts willing to consider them, and is international human rights law really useful in local practices as how we imagine it in terms of states' obligations or international monitoring, including there is more visibility of intersex and transgender rights at the moment in the United Nations. So I wonder how local activists link their advocacy to this international trend. Thank you.
Actually adding to that, considering kind of international pressure and local tensions, I was wondering with these case-based kind of legal activism, how much respectability politics plays into in terms of who's represented, who's not, and the kind of public debate that takes place in the following. Was there another person?
Is there one?
Yeah, just.
Okay.
I was just wondering if you could clarify a bit, because you talked about the Malta Declaration coming out of an intersex international forum. So I was just wondering. I don't know very much about it, but I believe that there are multiple conditions that fall under intersex, as in obviously. What Geeta was talking about, androgen insensitivity disorder, Turner syndrome, so we're talking chromosomal disorders, but we're also talking physical disorders. Things I was thinking things like hyperspadias and things like that. And so I was just wondering, do certain kind of like LGBTQIA collectives, do some voices become more visible than others? I guess that's what I wanted to ask. Thanks.
Okay, there are 5 questions. Let's answer the first two first, because the first two are more related. They are related to reservations. So first of all is, if you have the reservations for trans people, but they are still criminalized under Section 377 or other laws, how would that play out? And the second question is, you just mentioned that well, for the reservations we can have a board to determine, or some certification only for the reservations, but would that kind of board still exclude some people, because it will still, especially if it still employs some kind of medicalized criteria?
So let me answer the first one first, and that is about 377, and it's very strange. So the two judgments, one is this National Legal Services Authority judgment on transsexuals, and the other is the 377 judgment by the Supreme Court. Both came virtually at the same time, and the two are diametrically opposite. And I think it just shows how the makeup of a bench of judges makes a difference to the perception. I think if this bench had heard the other matter, we would have sailed through on decriminalizing 377 in consensual cases. But you got this hugely conservative bench, you got a government that was seesawing and not knowing what to say, whether to oppose it or not, and finally opposed it. And you got a bench which was not strong enough, even though we had a high court from which the appeal had gone to Supreme Court that had given a beautiful judgment decriminalizing it. So this is clearly inexplicable, so I cannot explain it. So all I can say is a bunch of lawyers filed a review, very senior, very respected. I think it's still hanging fire, because how do you justify a review within 6 months? The fact is that it is a ground for review. I mean, there is a reason to review, but that's the problem. So you are right. On one hand, you are doing reservation. On one hand, you are recognizing it. And the second judgment, which is the one on transgenders and reservation, literally glosses over it, saying that, look, they've already decided this issue, so we are not touching it. Because they had no other choice. If they discussed it too long, they wouldn't have been able to make this judgment, pass this. Now, the second, should I answer the second one?
Yeah.
So, your question was, how would the board deal with cases, say, if there's only a psychological reason for a transgender? So, the sad part, and this again in one of the criticisms of the bill, the transgender bill, is that it says it does not describe what they mean by transgender as well as by trans. They just use the language absolutely loosely. So they have no guidelines. The Act doesn't give guidelines. Where will there be guidelines for that poor committee that will sit? If we were to go by the Supreme Court judgment, you don't need a committee. But if the enactment says you will have a committee, the only reason that you can say is that it says there should be a psychologist or a psychiatrist. So therefore they would take into, and that itself is the very definition of, generic definition of transgender, a person who may psychologically feel that way. So any logical reason should say it should include. But the fact is, there are no guidelines, there is no definition in the enactment. So this is one of the other criticisms of the enactment, of the bill. And that's why people have said, take back the bill and make a more sensible and send it back to Parliament. So that's it. These are the first two.
Yeah, I'll answer the last three, and if you have anything to add,
Yeah,
then you
sure.
add. Yeah,
Sure.
there are three more questions. I'll answer the last one first, because the last one is the question which I have no answer to, and I don't want to speak on behalf of the intersex community. So, yeah. But I can only mention that the Malta Declaration is very clear on depathologizing classifications of intersex people. So, I would say it's unlikely that they will want to exclude anyone from the intersex community purely based on medical classifications. But I can't speak more of that. The other two questions, I have so much to say about these two questions, but I will limit them. The first question about activism. International human rights treaties is actually, I was like, this is something that I left out from my presentation. I was hoping that someone might ask. I don't know why actually someone asked. So international human rights treaties are actually very important for intersex people. Actually, one of the most important breakthroughs for intersex rights were in the international human rights arena, and this is also something that Hong Kong particularly has something to offer, because in 2 years ago, Small, which is the intersex activist which I talked about, and we traveled to Geneva to the Committee Against Torture, which is a monitoring body for the Convention Against Torture, which is one of the most widely ratified international human rights conventions. And this committee has already issued quite a few recommendations in relation to Switzerland, to Germany and Switzerland, I think. They made a few recommendations, including postponing all corrective surgeries performed on intersex children until they have consent, including providing redress for any intersex persons who have suffered due to these surgeries, and other recommendations. But in these two situations, they only did so because the national biomedical councils in Germany and Switzerland has already made similar recommendations. So the committee was able to act on the lead of national authorities. But in 2015, when we went, the Committee Against Torture made the same recommendation for Hong Kong, which was the first time they made a recommendation on any jurisdiction outside Europe. They also, in the same session, they made recommendations for other countries like France and Austria. So they're really now taking up this on board. They're really now taking aboard the idea that intersex rights are human rights that are protected at least by the Convention Against Torture, and they are very useful because we've been using this recommendation in our advocacy all the time, because this is the best thing about UN. Not a lot of very good things about UN, but the best thing is they have a lot of legitimacy, at least in politics, in law and politics, and courts do take it a bit. Like the Nassau judgment referred to a lot of UN human treaties. Not all courts are like that, but they are definitely influential and useful, and especially because the important thing is because intersex community, they are very strong in Geneva, and they're very strong in the international arena. And I think that's partly because that is also the arena where they can collectivize best. Whereas when you spread to each country, then simply because of the nation of the there was one intersex activist for a long while in Hong Kong, and they're much better at collectivizing when they can go to international arena and meet intersex activists from all around the world. So that helps a lot. The other about respectability politics, I can say so much about that, but I think your concern probably came from, for example, how marriage equality judgments would. For example, when U.S. when U.S. handed down the decision in marriage equality, everyone on Facebook was sharing this very memorable conclusion from Justice Kennedy, saying that the marriage is one of the most sacrosanct institutions, and without which gays would be condemned to loneliness. I'm not married, I'm not lonely, but that's very easily the kind of message that they would send, and they were also because gays are not diseased, that therefore they need to be respected. But that completely breaks down, I guess, especially yes, intersex people don't want to be should not be pathologized, but the fact that sometimes they have medical conditions should not be a disqualifier for any rights. So that kind of respectability politics is indeed a problem, and that is the kind of argument that you can't really say this. And also the thing is, if you how to depathologize, but at the same time ensure access to health treatments whenever they have to. But I don't think it's inevitable. It's a matter of judicial attitude, because some courts, such as South African courts, are much better at dealing with these concerns. But that is partially because South African court judges, a lot of them have activism backgrounds, so they know more. But courts in this country and many other countries that follow, like Hong Kong, which follows a lot in the UK, they are much less capable of dealing with that. But it is not an inevitable problem. Do you have anything?
No, not really. I mean, all that I could say is that in India we have the constitution provides that we should make enactments in keeping with the UN and international conventions. So there's Article 253 and 51, which is like a directive principle of state policy, saying that's the kind of legislation we should bring in. But unlike the US, which says that they are part of the law even without enacting. So that's the difference.
Okay, so we'll conclude the session. We don't have that much time, but I think it's very important to have more and more inter-regional discussions. I think especially important for intersex rights. It's especially important. Unfortunately, we don't have intersex voices on the panel, but like you can look up like very easily. Like nowadays, internet is so accessible. You can look up all the different intersex groups from your region and support them and help them in any way and connect. Like now that you're here, connect them to like activists from around the region. And thank you for everyone.
I'd like to thank our panellists, and unfortunately we've run over, so we won't be taking the 15-minute break. We'll just have a quick turnaround before we welcome our last speaker of the event, which is Najah Al-Ali, to talk about feminist and queer perspectives in West Asia. So join us in the next 5 minutes.